we have an email that was previously marked confidential but is now public, and shows that you asked about making edits to an op-ed that read the following, and I quote, "First of all, it is widely understood, accepted by legal scholars across the board, that Roe v. Wade and its progeny are the settled law of the land," end quote. You responded by saying, and I quote, "I'm not sure that all legal scholars refer to Roe as a settled law of the land at the Supreme Court level, since court can always overrule its precedent, and 3 current justices on the court would do so." This has been viewed as you saying that you don't think Roe is settled. I recognize the word said, it's what legal scholars refer to. So please, once again, tell us why you believe Roe is settled law. And if you could, do you believe it is correctly settled?
So thank you, Senator Feinstein. In that draft letter, it was referring to the views of legal scholars, and I think my comment in the email is that might be overstating the position of legal scholars, and so it wasn't a technically accurate description in the letter of what legal scholars thought. At that time, I believe Chief Justice Rehnquist and Justice Scalia were still on the court at that time, but the broader point was simply that I think it was overstating something about legal scholars, and I'm always concerned with accuracy, and I thought that was not quite accurate description of all legal scholars, because it referred to all. To your point, your broader point, Roe v. Wade is an important precedent of the Supreme Court. It's been reaffirmed many times. It was reaffirmed in Planned Parenthood versus Casey in 1992 when the court specifically considered whether to reaffirm it or whether to overturn it. In that case, in great detail, the 3-justice opinion of Justice Kennedy, Justice Souter, and Justice O'Connor went through all the factors, the stare decisis factors, analyzed those, and decided to reaffirm Roe. That makes Casey precedent on precedent. It's been relied on. Casey itself has been cited as authority in subsequent cases such as Glucksberg and other cases. So that precedent on precedent is quite important as you think about stare decisis in this context. A similar analogy, the United States versus Dickerson case in 2000, where the court considered whether to overturn Miranda versus Arizona or to reaffirm it. And in that case, the court, through Chief Justice Rehnquist, specifically reaffirmed Miranda, despite the fact that Chief Justice Rehnquist had been a critic of Miranda in his early days and had written some opinions quite critical of it. It became that, so that Dickerson case is similarly precedent on precedent, which is important going forward as you think about the stare decisis calculation for a case like Miranda. So that's why both of those cases, Planned Parenthood versus Casey and Dickerson, are cases where I would refer to them as precedent on precedent.
So you believe it's correctly settled, but is it correct law in your view?
Senator, there's on that case or on Dickerson or on cases like Citizens United or Heller or United States versus Lopez or Kelo, just the whole body of modern Supreme Court case law, I have to follow what the nominees who've been in this seat before have done.
Judge, a yes or a no will do.
Well, I'm just, if I can briefly explain.
Yes, you can.
Briefly, I'll try to be brief, but when you're in this seat, I'm not just sitting here for myself, I'm sitting here as a representative of the judiciary and the obligation to preserve the independence of the judiciary, which I know you care deeply about. And so one of the things I've done is studied very carefully what nominees have done in the past, what I've referred to as nominee precedent. And Justice Ginsburg, but really all the justices, have not given hints or forecasts or previews. And Justice Kagan, I think, captured it well, as she often does, in talking about questions like the one you're asking. You can't give a thumbs up or thumbs down and maintain the independence of the judiciary. So I need to follow that nominee precedent here.
Okay. Mr. Chairman, could I ask that the email at issue be made part of the record?
Pardon me?
I'd like
Yes.
to ask that the email at issue be made part
Yeah,
of the
we'll
record.
be happy to do that. Thank you. During your time in the Bush White House, the administration actively took steps to limit women's reproductive choices. This included reimposing the global gag rule to prevent foreign organizations from spending their own money on reproductive health, and trying to prevent the FDA from making Plan B contraception available over the counter. During your service at the White House, 2001 to 2006, did you work on any issues related to women's reproductive health or choice?
President Bush was a pro-life president, and so his policy was pro-life, and those who worked for him, therefore, had to assist him, of course, in pursuing those policies, whether they were regulatory. There was partial birth legislation that was passed as well. And some of those things might have crossed my desk. I can't remember specifics, but I think this came up in Justice Kagan's when she worked for President Clinton. He had a different view than President Bush on that issue, and she had some work for President Clinton. I consider myself working for President Bush. Was there to assist him.